An electrical contractor wraps up a commercial job. The rough end looked fine. Crew moved fast. Customers ready to open up. Then inspection day hits. The inspector walks the site, starts taking notes, and suddenly the conversation changes. Now it's not just a punch list issue. Now it's multiple code violations. We got delayed payment, we got an angry owner now, and maybe we even have a written complaint to electrical board. And then 2 weeks later, you get a letter from the North Carolina State Board of Examiners of Electrical Contractors. That's the moment a lot of electricians realize something too late. A failed inspection is not always just a failed inspection. Sometimes it becomes the beginning of a licensing problem. And if you handle it the wrong way, especially in writing, you can make a bad inspection a lot worse. If you're an electrical contractor in North Carolina, this is a topic you need to understand because a lot of good license holders assume inspection issues stay at the local level. And sometimes they do. Sometimes they absolutely do not, though. I'm Nick Dowgul with North State Law here in Raleigh, North Carolina, and my practice focuses on helping licensed professionals and regulated businesses deal with investigations, complaints, board discipline, and license risk. And if you're an electrician, electrical contractor, or a qualifying party in North Carolina, then this video is absolutely for you. Today, I want to walk you through what can happen after a failed inspection, when that can turn into a board issue, what mistakes tend to make it worse, and how to think about the situation before it starts affecting your license, not just your job. Because once the issue leaves the job site and enters a regulatory file, you're playing a very different game. So before we get into the process, it helps to understand what's really going on here. A local inspection is usually about one thing. Does this work comply with code, and is it safe? But from a regulatory standpoint, the bigger concern is often this. Was this a one-time correction, or is this evidence of a broader competence or supervision problem? That's where people get tripped up. Because a lot of contractors think in terms of, can I fix this? Can I get that passed? Can I get paid? And all of those are very, very valid concerns. But the board may be thinking in terms of, was the work unsafe? Was this avoidable? Does this reflect poor workmanship? Has this happened before? Does this contractor have a pattern here? And that's a totally different lens, right? And when you understand that, you start to see why some inspection failures stay small and others become much more serious. So let's look at a distinction here. We're going to talk about failed inspection versus a license violation. So we're going to start with the most important distinction. A failed inspection is not automatically a licensing violation. And that part matters a lot, because if a failed inspection triggered discipline, we would have a lot of electricians in front of the board in North Carolina. Inspections fail for all kinds of reasons. Most frequently, though, it's like missed details, interpretation issues. Sometimes you'll have incomplete work, sequencing problems, crew mistakes, or just things that need correction before there ends up being approval. That by itself is not necessarily a disciplinary event. But here's when things start changing. When the inspection issue suggests something bigger than an isolated mistake. That can include things like repeated code deficiencies, like constantly having the inspector coming back and saying, well, this wasn't corrected, or obvious safety hazards. So we're doing electricity, that is a big concern. Also, you could have work being done without proper permits, unlicensed practice issues, work outside the contractor's classification, or a pattern of poor or non-existent supervision. That's when the question becomes, is this just a correction issue, or is this potentially evidence of incompetence, negligence, or misconduct? And again, that distinction is huge, because the moment a failed inspection becomes part of a consumer complaint, inspector referral, or board inquiry, you are no longer just solving a construction problem. You're now potentially defending your professional judgment. That is a very different posture. A lot of contractors assume if I fix it, it goes away. And sometimes that's true, but not always, because fixing defective work does not necessarily erase the fact that the work was allegedly unsafe or non-compliant in the first place. And if someone has already documented it, especially an inspector, an owner, or municipality, you may already have a record that lives beyond the correction itself. That's where people get surprised. So let's talk about what tends to move a failed inspection from job site problem over to licensing problem. There usually needs to be some kind of escalation point. Otherwise, it would just be a fix. Inspection eventually gets fixed and you move on. In an electrical world, that often comes from one of a few places. If we have unsafe wiring or safety-related deficiencies, if the cited issues raise above life safety concerns, that tends to draw a lot more attention. For example, we have grounding and bonding errors, panel issues, overcurrent protection concerns, improper terminations, service equipment problems, lack of proper protection equipment, or anything that could create shock or fire risk. When the concern looks like more than a technical correction and instead looks like dangerous work, that can raise the stakes pretty quickly. Another one that we get is a big one, and that's repeated violations or recurring deficiencies. Because one failed inspection might be frustrating, but multiple failed inspections involving the same type of issue can start to look like a pattern. And patterns are what regulators really do care about, because a pattern is going to suggest lack of competence, lack of supervision, poor training, or careless business practices. You want to work with permits, and you want to make sure that you're not working outside of proper scope of the job. This one can create a whole different category of exposure. If the issue is not just how the work was done, but whether the work should have been performed under that license or under those circumstances at all, that can trigger deeper scrutiny. Another one is consumer or owner complaints. A failed inspection by itself might not go very far, but a failed inspection plus an angry customer, a member of the public, that's often where the file gets created, because now you have documented deficiencies. You've got alleged financial harm, you've got some project delay, and now you've got a complaining witness. That combination is dangerous. Another one is inspector documentation. A lot of electricians underestimate how important inspector notes, correction histories, and written observations can actually become later, because those records may not just stay in the permitting process. They can and will become part of the story someone tells about your competence. And once that story starts forming, it can be hard to unwind if you respond badly early on. This is where most electricians get into trouble. And it usually isn't the inspection itself. It's how they react after the inspection. This is the part that causes a lot of very avoidable damage. So mistake number one, arguing emotionally in writing. Angry email to the inspector, hostile text to the owner, a defensive explanation sent way too quickly. That stuff feels so good for about 5 minutes. Then later, it becomes evidence. And once it's in writing, it can be read in the worst possible light. It can be read as being dismissive, it can be read as being careless, combative, or knowingly non-compliant. That is not where you want to be. Mistake number two, trying to explain away the issue too casually. A lot of contractors say things like, we always do it this way. Oh, that's not a big deal. Well, the crew must have missed that. We were going to fix it later. The problem is statements like that can accidentally sound like admissions of poor supervision, accepted shortcuts, or knowing code deviations. So let's look on mistake number three. Cleaning up records after notice. And this one can be pretty dangerous. If there's already been a complaint, investigation, or formal inquiry, suddenly, quote, fixing documents like changing internal notes or reconstructing records after the fact can create a completely different problem. Even if your intention is just to organize things better, it can look bad if the timeline becomes questionable. So let's look at mistake number four, treating the issue like it's only a field problem. Once the issue is being documented by third parties, it is no longer just a field issue. At that point, it may also be a record issue, it could be a communication issue, it could be a supervision issue, and it could potentially be a licensing issue. That's why a lot of people get blindsided. They think they're still fixing a rough-in, for example. Board may be evaluating whether they should trust that license holder going forward, though. So let me give you a realistic example. We got a hypothetical here. Let's say Rob is a licensed electrical contractor handling several small commercial build-outs. He is busy. He's also short-staffed. He's delegating a lot to field crews. On one job, the inspector flags multiple grounding and bonding deficiencies. Annoying, but fixable. So Rob gets the corrections done and moves on. Then, on another job a month later, a similar issue shows up again. Then again on a third project. Now the local picture starts changing. At that point, the issue may no longer look like just, quote, one imperfect job. It may start looking like a contractor with a recurring workmanship or supervision problem. Then the owner on one of the projects gets upset about delays and extra costs, and they file a complaint. Now there's inspection history, repeated deficiencies, and a consumer complaint. That's often enough to create a much bigger issue. And if Rob already sent emails saying things like, wow, the inspector's just being ridiculous, or this is how everyone does it, or we'll just patch it and get through it, those communications can suddenly become much more damning than Rob originally expected. Why that matters legally? Because from a regulatory standpoint, the issue may no longer be limited to whether the work got corrected. Now the concern may be whether the contractor exercised competent oversight, safe judgment, and professional responsibility. That is the kind of shift people often do not see coming. So, what happens when that complaint letter shows up? Usually, the first thing to understand is this. You may be entering an administrative process, not just a customer dispute. And that matters because administrative cases have their own rules, they've got their own timelines, they come with their own risk, and they have their certain consequences. Depending on the situation, that process may involve a complaint review, a request for records or written explanation, witness statements, inspection records, permit history, and potentially a formal disciplinary track. That doesn't mean every single inquiry ends in severe discipline or any discipline at all. But it does mean this is not the moment to be casual about it. Because what regulators often look for is the following. They may be trying to understand, was this an isolated event or a pattern? Was the work unsafe? Who supervised the work? What was the contractor's role? How did the contractor respond once the issue was identified? And that last one matters a lot because in many professional licensing cases, not just electrical licensing, the response after the problem can influence how the entire matter is viewed. Not always, but often. So if the record shows disorganization, maybe evasiveness, hostility, or lack of oversight, that can make the situation harder to contain. Now, without turning this into legal advice for every single situation, because I'm not doing that, there are a few general principles that matter here. So you want to treat inspection failures like they may be later reviewed by somebody else, because they might. Don't just assume the audience is only the inspector or the owner of the property or your field crew. Sometimes the audience later becomes board investigators, other participants in the disciplinary process, or disciplinary decision makers like board members. That mindset alone changes how you document and communicate with people. Remember, the mission of the board, and they'll tell you, it's to protect the public. So next thing is we want to preserve records. Generally speaking, one of the most important things is having a clean, clear, consistent record of what happened, who was responsible for what corrections were made, and when they were made. Not because paperwork wins everything, but because poor records often make a fixable situation much harder to defend. Don't make informal missions you don't fully understand. A lot of people talk themselves into trouble trying to sound cooperative. There's a difference between being professional and casually saying things that later get interpreted as admissions of incompetence or knowingly unsafe practice. Understand that supervision is often part of the case. Even if you personally didn't land every termination or touch every single device, that does not always end the analysis. If you're the license holder or qualifier, supervision and responsibility issues may still be part of the conversation. That's why these cases often become more serious than people initially expect. And we also need to look at early decisions because those matters. A lot of damage in licensing cases happen early before anyone thinks they need to be careful. That's true in a lot of professional board matters. And by the time someone realizes the issue is bigger than a failed inspection, they may have already created unnecessary exposure for themselves. A failed inspection does not automatically mean you're headed for discipline, but in North Carolina, it can become the first documented step in a much bigger licensing problem, especially when there are repeated issues, safety concerns, bad written communications, or an unhappy customer attached to it. So the takeaway is simple. Inspections test your work. Board investigations test your professionalism. And those are not the same thing. This doesn't mean the system is always unfair. It means it can be unforgiving if you misunderstand what's really at stake. If this is the kind of topic you deal with in the trades world here in North Carolina, make sure you check out the other videos on this channel. I've covered more issues involving license risk investigations, complaints, and regulatory problems that could affect contractors and other licensed professionals before they realize how serious the situation actually is. So if you want to keep learning how these cases develop and what tends to make them better or worse, go watch the next video here on the channel. Thank you so much and keep the lights on in North Carolina. Bye-bye.